Hi, I'm attorney Aaron J. Boria, and today I'm going to be talking about breathalyzers, refusing them, and the consequences. Clients often come to me and ask if they've been pulled over for drinking and driving, should they refuse a breath test? What you have to understand is that there are two types of breath tests. The first type of breath test is the preliminary breath test, also known as a breathalyzer. It's a handheld device that the officer will usually ask the subject to blow into at the scene where they've been stopped. So a lot of times this is a test that's offered right on the side of the road. A person blows into it and the device will display a number that is supposed to correlate to the level of alcohol in a person's system. Refusing the preliminary breath test can result in a civil infraction, meaning that it's not criminal, that there is a fine associated, but there are no license consequences. The second type of testing that occurs in a drinking and driving situation is a test that is administered after a person was arrested. So that means that usually this test has occurred when the person has already been put in the back of a patrol car, taken to the police station, or possibly taken to the hospital. The test that is done at the police station is usually through a device called a Datamaster or a Datamaster DMT. It's a fancy breathalyzer that a person blows into, and it will display a number that is supposed to reflect the level of alcohol in their system. It is also possible that an officer will ask you to submit to a blood draw that will eventually be sent to the state's laboratory, and that will come back with a blood alcohol level as well. Urine testing is also possible, but it's rarely done. A violation of Michigan's Implied Consent Act can result in 6 points on your license and a full 1-year suspension of your driving privileges, which means no driving at all. Refusing the preliminary breath test, the handheld device offered before you are arrested, may result in the officer not gaining enough probable cause to arrest you for drinking and driving. It is possible that even without the test that the officer may still have enough evidence against you to arrest you for drinking and driving. And in that case, you may face a drinking and driving charge as well as a civil infraction for the preliminary breath test refusal. Refusing the implied consent law, or other words, refusing the chemical test after you've already been arrested for drinking and driving, will likely result in a violation under Michigan's Implied Consent Act, as I've explained, which means 6 points on your license and a 1-year suspension. And what will likely happen is that the officer will be able to get a warrant to have a blood draw done, and then the police would still have evidence that they could use against you. Every case is different, so it is hard to say whether or not it is better to refuse one or the other, but just realize that the consequences of refusing the implied consent law can be very severe. Again, I'm Aaron Boria, and I am a criminal defense lawyer. I've handled drinking and driving cases all over the state of Michigan. So if you've been charged with drinking and driving, call my office today, 734-453-7806. We are here to help.